Esteemed members of the jury, Dr. Anurag Batra, learned panelists, ladies and gentlemen. At the very outset, I must say that the business world has accepted many varieties of the legal profession, which has been able to introduce the concept of specialization in many an arena. This recognition requires a modern mindset. It pleases me the most, as well as I get immense satisfaction. I am speaking about these two pillars because both have economic and social impact. When there is growth of economy, it requires expertise, skill, and guidance. All these come from various spheres and indubitably from the sphere of the legal leaders, the professionals. Whenever there is amity, amiability, and peace in the society, it is because there is economic growth and economic activity, and that apart, there is a sustenance and stability of law and order. Not for nothing, James Forstall has told us, and I quote, the only way in which a durable peace can be created is by worldwide restoration of economic activity and commerce, unquote. This gentleman, this thinker, this philosopher has been able to conjoin the idea of peace and harmony with economic activities. All three are extremely important for our civilization and humanity. As we see in the modern world, there is tremendous growth of expansion. Do not take into consideration the pandemic. I am speaking about the pre-pandemic era and also when we jump into the normalcy again. The concept of digital environment is one of the factors that plays as a catalyst for economic growth. It is because it has a global reach and it has infinite capacity, tremendous connectivity, and complex potentiality. It has the ability to innovate. There is a phraseology that the human mind is able to digitally express itself. When the digital expression takes place in a very rational and authentic manner, there is an economic growth. Now, let me focus on arbitration. When India had its rendezvous with the globalization, there was expectation in many spheres that there would be definite changes in the laws of arbitration because we needed an effective dispute resolution system. And the laws changed, and India started to become a propeller of commercial arbitration. When the new era came in, the tendency amongst the litigants started to curb. Earlier, when the Indian arbitration used to take place, there used to be a tendency to take adjournments, rush to the court, get stay orders. But now there is a development of the mindset by which the legal practitioners are really entering into opposite arbitration and with a different kind of mindset, because they are really keen on getting the final result. In the modern world, time is money, and everyone tries to save money. Apart from that, there has to be a change, I would like to say, a further change in the mindset. The efficacies of arbitration have to be told to the litigants. They must understand they are the disputants and they choose a forum, and therefore they must participate without reservation and innovation. I must tell you at this juncture of time, adjournment is a disease, and all attempts and endeavors to be made to abandon and ostracize this disease. And this can be done by the adjudicators, by their strictness, and by the lawyers, by their self-cultivation and cultured discipline. And I'm sure if there is no prayer for adjournment, unless it's extremely necessary, the arbitration can further be quickened in India. We need a stable and vibrant ecosystem for arbitral institutions. Whenever an institutional arbitration takes up, we require to have a credible, efficient, able, and transparent method of arbitration. It's a great challenge. That apart, the leadership of the institution should be proactive, and it must get the support staff who are qualified and are in a position to work hard and assist, so that we have a work culture in arbitration. This is apart from the technological infrastructure and physical infrastructure. Sometimes we lay much stress on these infrastructures, but we must have the ability infrastructure in place. When I say ability infrastructure, I give stress on the quality-oriented research and assistance. We must develop arbitration literature, which comes from discussion, deliberation, seminar, workshop, and in-depth learning. This literature has to be spread, and there the institutions, the centers, and other organizations have a formative role. We have to see that the young minds grow in that sphere and the literature really springs up. We must understand that the arbitration is a universal institution. It is not an individualistic perception. Georgi Jakubowski speaks that it's a product of universal mind. When we are living in a universe and competing, we have to really pave on the path of competition. This competition has to be healthy, but not a kind of enviable or jealous competition. When we really compete with a proper mindset, having a feeling for healthy competition, I'm absolutely certain we will attain the enviable position. All of us talk that India will become a hub for international commercial arbitration. But I must tell all of you, we have miles to go to achieve that. It's because we have to really have appropriate laws in that regard, the respect for international arbitration compositions, and must develop ourselves. We must show it in our action. You see, there was a gentleman named Dr. Steve Moravali, and he says, absolute emphatically, and I quote, the universe doesn't give you what you ask for with thoughts. It gives you what you demand with your actions. It clearly means act and act so that you can really make India a hub of commercial arbitration. Having talked about arbitration, let me proceed to the arena of mediation. Mediation, apart from its conceptual meaning, its etymological essentiality, it engulfs the basic idea of sincere solution of a lease. When a litigant comes to a court and is suggested about some kind of alternative method, be it arbitration, unless a contract is there, or mediation, he will ordinarily ask 4 questions. What will be the gain? Because he is really concerned about the result of his case. What will be the result? What will be the efficacy? Will it be cost effective? These questions are absolutely normal. The United States of America had a Chief Justice, Warren Burger, and he had said, with a touch of humanity, people with legal problems, like people with pain, want relief, and they want it as quickly and as inexpensively as possible. He compares a litigation to a physical or mental pain. Look at the empathy. Similarly, in the process of mediation, we must have this kind of empathy. When I talk about mediation and in the sphere of economic development or economic activity, economic settlement, I keep in mind two concepts, psychology and pragmatism. Whenever there is a settlement through mediation, business improves. There is a growth of economy. And remember, the controversy is not put to rest in present time. The controversy is put to rest forever because there is no execution. People accept it and they obey it. And therefore, it establishes intergenerational peace and happiness. Having said that, let me now tell you something. What is really required on the part of a mediator to be an effective mediator and to understand mediation as a tool for arriving at sincere solution of a property dispute or a money dispute or a domestic dispute or a commercial dispute. There are two components. One is mediation. One has to understand that it's a legal science. And second, it's an artful craftsmanship. In the Department of Legal Science, I would like to put one, diagnosis, second, prognosis, third, potentiality of contagiousness, and fourth, constitutional and symptomatic remedies. When I say constitutional, I do not mean the Constitution of India. I mean the constitutional basis of the problem. Now, traveling to the concept of artful craftsmanship, I would like to put in or divide the same to four facets, namely psychological base. A man, a litigant, may have the egotism, and that is connected with the psychological base. Psychographic balance, it has some nexus with geography, a territorial mindset at times. Reduction of litigation pathology. And last one, a broader therapeutic counseling to break the positional stand. And let me tell you, ladies and gentlemen, when settlement takes place in commercial matters, by understanding the concepts I have mentioned, there is economic growth as well as social healing. And social healing is a categorical imperative for our progress. Now let us understand another aspect. It is my concluding aspect I emphasize upon. Unless the litigants are absolutely egocentric and they have the attitude of a Duryodhan who says that I shall not leave an inch of land without war, then the matter would be difficult. But barring those categories of people, all others have a hidden desire in them that someone elderly, someone unbiased, someone courteous, someone understanding would come and discuss with us and may be in a position to solve our problem. This is the psychological seed which is there in his heart. A true mediator can bring in this psychological seed to the forefront, and by which the settlements can take place. And when the arbitration and mediation come to the forefront in this country, I am absolutely indubitable there will be economic stability, social peace, and human progress. With this hope and optimism, I conclude and thank the organizers and all other participants. I am sure the discussions during the day shall be absolutely successful. Thank you. Thank you very much.